I'm going to surprise some folks on this one. I am going to be looking at an issue when it comes to judge shopping and universal injunctions from the perspective that it's not good for either political party. This is a bipartisan issue that needs to be handled. Now, right now, with President Trump in office, these judges are doing things that are far above what many of the other incidences of this were, but no judge on a regional level should be able to do a universal injunction. End of story. That's not what their job is. They're supposed to only rule for their region. And there are definite political and legal arguments against this. So, you're going to be hearing first from Paul J. Larkin of the Heritage Foundation. I know there's going to be people, oh, it's the Heritage Foundation. Listen to him. He's not talking just on a conservative standpoint on this. If you are liberal, listen to him. He's actually making an argument that could impact a liberal president. No joke. The next person you're going to hear from is Representative Harriet Hagman of Wisconsin or Wyoming. I'm sorry. Um, she's got a very good point. And it also comes from a standpoint of, while yes, these judges are going after Trump, this can be used against Democrats. So let's take a look at what they have to say. This is over 10 minutes, I'm well aware, but these two perspectives I think that you should hear if you are actually interested in what is going on when it comes to these judges and how they're not on legal ground in any shape or form. So here we go. Howdy, y'all. This is Paul, the Redneck Thinker. What we have here is a channel to communicate. I want you folks to be thinking by the time you leave my videos. Why? Because I'm tired of people talking via what other people tell them to think. So, watch my video and enjoy the chance to think for yourself.
The practice of issuing nationwide injunctions outside the confines of a certified nationwide class action is mistaken as a matter of law and unwise as a matter of policy. Let's start with the law, and in there, let's also start with the Constitution. The legislative power is granted to Congress, and what is the primary product of that legislative power? It is what the Constitution defines as a law. The term law also shows up in Article 3, but it shows up in Article 3 under the phrase arising under the Constitution, the laws, or treaties. It is not the courts that are responsible for creating the law. It's the courts who are responsible for interpreting it as it applies. But they can only do so in the context of a case or controversy, two structural limitations on what the courts can do. In other words, in order for the courts to be able to say what the law is, they have to get on the playing field. And in order to do that, you have to have a case or controversy. Now, why does that matter? Well, the Constitution does speak to this. As I've said, only the Congress can create a law. Anytime a court enters a judgment that is tantamount to being a law, the judge has gone too far. And in the case of nationwide injunctions, a judgment in favor of non-parties goes too far. You also have no statute in the judicial code, no provision in the Constitution, and no settled history at common law that allows a judge to enter these sorts of orders. That's important because everything has to fit into one of those three. Why? The Supreme Court has interpreted Article 3 in light of how it was understood in 1789. And so those are the three primary bases that you have to look to: the text of the Constitution, statutes, and English common law history. In fact, there are two Supreme Court cases that directly undermine the legitimacy of nationwide injunctions outside of certified class actions. One is Williams versus Zabarez. In that case, the court said there is no case or controversy between two parties that are in a case over an issue that has not been put into dispute by one or the other of them. It logically follows that there is no issue in dispute between someone who is a party and someone who is a stranger to the entire litigation. Similarly, at the back end of the process is the case of United States versus Mendoza, where the Supreme Court held that the federal government is not subject to the win or go home rule that you see in the NCAA postseason tournament. The government isn't stuck with whatever loss it has the first time it litigates a case to a final judgment and loses. The doctrines in the law of issue preclusion or collateral estoppel, the new and old terms, do not apply to the federal government. Why? The Supreme Court, in the unanimous decision in Mendoza, said they do not. Why? Because there are a variety of good policy reasons why it shouldn't. With that, then let me turn to the policy reasons that show this practice is unwise. There are several, okay? First, mandatory injunctions prevent the percolation of issues in the lower court that the U.S. Supreme Court in Mendoza said is necessary for that court to be able best to resolve whatever legal dispute there is. It allows the court to be sure that all of the issues, all of the sub-issues, all of the arguments pro and con, all of the benefits and costs of whatever rule are fully aired. Secondly, it encourages judge shopping. All you have to do is find one favorable judge, and you can stop an entire administration in its tracks. And as you know, it has happened to every administration over the course of this 21st century, from the George W. Bush administration to the present. Each party has been subject to this practice. Third, it can result in conflicting nationwide judgments. You can wind up with injunctions going one way and the other way because a court in Maine and a court in Alaska can come out the opposite way in a case. Finally, they are going to weaken the doctrine of stare decisis, because as the Supreme Court comes to realize, if it has to decide issues at a preliminary stage of the case without the guidance of the lower courts, they're going to have to overrule some of their decisions. Let me end where I began. This practice is mistaken as a matter of law and unwise as a matter of policy. Thank you.
In March, the Miami Herald reported on a team of former U.S. officials and Venezuelans assisting the Trump administration with tracking Tendagua, or TDA. They have focused on ties between TDA and the Maduro regime, identifying 1,800 gang members sent to our country. Reportedly, 300 received paramilitary training in Venezuela, and the regime has operational control over them. Information obtained by the team from police agencies in South America has resulted in the arrest of at least 800 TDA members or smaller affiliated entities. According to the article, TDA has been setting up a drug distribution system in our country, and the individuals, quote, are not criminals sent to cause havoc. They are soldiers sent in an asymmetrical warfare operation against the United States, end quote. On March 15th, President Trump issued an EO invoking the Alien Enemies Act regarding the TDA invasion. The EO finds that TDA is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. TDA is undertaking hostile actions and conducting irregular warfare against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. Judge Boasberg of the D.C. District Court recently ordered the Trump administration to turn around removal flights bound for El Salvador carrying members of this Venezuelan terrorist group, TDA. Judge Boasberg's temporary restraining order at first was limited to the named plaintiffs, but he later provisionally certified a class for, quote, all non-citizens in U.S. custody who are subject to President Trump's order against TDA and its implementation. Mr. Larkin, what are the problems associated with the breadth of this order rather than it having being just applied solely to the parties in front of it?
There seem to be at least two issues. One is whether I'm told, I haven't seen the complaint, but I'm told that the complaint that was filed seeking relief was brought under the Administrative Procedure Act. That's not an appropriate vehicle for this. It should be the federal habeas corpus laws. But secondly, if you're going to grant class-wide relief, you have to first properly certify a class. The Supreme Court has so ruled and has told the district courts that they have to do first the job of certifying the class and only then awarding class relief. In footnote 1 in Baxter versus, I think it's pronounced Palmigiano, but don't hold me to that, the Supreme Court said the district court had gotten it wrong in that case for following the reverse order. So if that's what happens then is you're seeing some of the problems that can arise when a judge wants to stop an entirety of the government rather than award relief to one person, because there are steps that you have to go through in order to certify a class. And to my knowledge, although, like I said, I haven't followed that case, I don't know if those steps were followed here. My understanding is that this is the first I've heard of it from you, so.
Well, and there's another problem associated with that as well. In the case involving TDA, the judges and other injunctions that have been issued, nationwide injunctions issued by these courts, they have not been requiring the party seeking the injunction to put up a bond, even though Rule 65 of the Federal Rules of Civil Procedure mandates that a party seeking a preliminary injunction or TRO must provide security, a bond to cover potential costs and damages to the party who is wrongfully restrained or enjoined. In fact, such a bond is a condition precedent for an injunction to be valid. So in light of that, does this violation or failure to require the posting of a bond undermine, if not actually nullify, the legality of Judge Boasberg's order?
I have to say, and it's going to sound like begging off, but I'm not trying to, that I haven't researched that effect in this sort of context, in part because I'm not sure how you set a bond in a case like this, where what you're talking about is essentially relief that should be granted under the habeas corpus laws. And so to the extent there are separate procedures that you have to follow in a habeas corpus action, I don't know to what extent that part of Rule 65 would apply.
So what I'd like to do is I would encourage you to read the opinion article in the the Wall Street Journal from yesterday entitled "Why Judge Boasberg's Deportation Order is Legally Invalid." And this individual, Daniel Huff, goes through the analysis of what is required under Rule 65 for an injunction to be enforceable.
Yeah.
And one of the problems associated with the decision is the fact that no bonds have been required in these injunctions.
And not every provision in the Federal Rules of Civil Procedure automatically translates over to habeas corpus, and I just don't know if that provision does. If it does, then it has to be addressed. If it doesn't, then you have a different set of rules that you follow.
Would the gentlelady yield for 1 second?
Sure.
Would your
Mr. Chairman,
thank you. Would your question be for all of these cases, not just the one that you were speaking of?
That is.
You heard all of those legal arguments. A lot of stuff that you may not have heard of, but if you think about it, this is something that affects you no matter who you are, no matter what political persuasion you are, it affects you. Why? Because these issues are being turned into political minefields that are supposed to be being looked at as a legal issue. And if they're not on solid legal ground, then guess what? It causes all kinds of issues. It causes all kinds of arguments. So we need to get back to having our legal system quit being political and start being more legally grounded. Now, I'm well aware that politics have always had something to do with the legal side of things. But in this case, they are going far too political. Way too political. So, that's why I thought these arguments from both Hageman and Larkin were exceedingly valid to everybody, no matter what your political persuasion is. So, this has been Paul, the redneck thinker, Y'all have a good day now. Bye. So, folks, that's the story that I wanted to bring you on this video. And I just wanted to say thank you again for coming by. Hit like, subscribe, comment, all that fun stuff if you don't mind. Help me out. So, y'all have a good day now. Bye.